Our next speaker, Bruno Bioni. Bruno, tell us more how the law, how the Brazilian LGPD actually deals with risk-based approach.
Yes.
Over to you.
So, are you hearing me well?
Yes.
Okay, perfect. So, first of all, hello everyone. I'd like to thank you, Boiana, Laura, Danilo, and Giovanna as well for having me. And as I was already introduced, my name is Bruno Bioni. I'm a lawyer and in the field of data protection and the founder director of Data Privacy Brazil, which is a think tank based in São Paulo. So our time is quite short, so I'm going to straight to the point. Following what Boiana has already said, a risk-based approach is about a regulation that is crafted on the assumption that compliance efforts should mirror or at least should reflect the risk level of each organization activity. And in the field of data protection, it means that the duties of data controllers and processors should be calibrated heavier or lighter according to their data processing activities if they are more or less risky. So having said that, my goal is just to verify if LGPD has adopted such regulatory rationality, and more precisely, I will try to point out what are the key provisions regarding it. So, in my opinion, the main provision is the Article 50, which clearly sends the message that organizations should, let's say, customize their data governance programs according to the features of their own data processing activities. So there is no one-size-fits-all data governance program or a silver bullet in which each organization should take into account the characteristics of their data activities in order to better calibrate their efforts in terms of compliance. And what are these characteristics? Article 15 provides some answers, such as you should take into account the structure, the scale, the volume of data processing, and as well the sensitivity of personal data that is being processed. Then it will be possible to evaluate the probability and the seriousness of damage to the data subjects, and therefore to design and adjust, and those are keywords here, design and adjust measures in order to manage the risks of data processing activities. Such mindset, I think it's quite different that we have seen so far in Brazil. Usually, such as tax law and other compliance areas, legal obligations are calibrated according to the size of the corporation, SMEs, startups, and etc. But in LGPD, the primary element to calibrate legal obligation is not the size of the corporation, but let's say the size of the side effects posed by its data processing activity. It's true that LGPD says the Brazilian DPA may alleviate some rules for SMEs, startups, and so on. However, this is not the only criteria, and I will say more. It's not the primary element for it. So why this is so important, Bruno? I think because data processors and controllers should be held accountable differently according to the risk level of their data activities, and this is vital to verify how much an organization should invest in terms of compliance, particularly when we will face an economic recession because of COVID, and more importantly, I think that is vital to not create a competitive distortions between economic agents. In a few words, such regulatory asymmetry, it's a regulator's duty and also a regulator's right that has broad consequence, even in terms of fair competition, for instance. And what else? Where can I note, even indirectly, that LGPD has adopted a risk-based approach? When LGPD deals with anonymous data, for instance. When LGPD draws the concept of reasonableness or reasonable efforts to differentiate personal data from anonymous data. Likewise, GDPR, LGPD acknowledge that anonymization process might be reversible, but what is important to identify if the risks of re-identification are tolerable, are reasonable, and then, therefore, again, it's a question about how to manage risks properly. Also, when LGPD deals with legitimate interests. As we know, LGPD provides 10 legal bases, much larger than GDPR, and one of them is the so-called legitimate interests that are considered as one of the most flexible ways to unlock data processing activity. However, such bonus, or if you prefer rights, are followed by a severe onus, if you prefer duties, that are detailed in the Article 10 of LGPD. And here, I think that DPA should play a very, very important role in order to clarify the latitude of those duties prescribed in the Article 10 of LGPD. Specifically, to clarify that a legal basis should not be, and this is my opinion, an element to define if a data processing activity is risky or not. The characteristics of data processing activity and not the legal base that it relies on should be the primary element for such analysis. And this will make a huge difference in terms of compliance efforts. For instance, instead of triggering a data protection impact assessment, such legal base should unlock by default another kind of documentation that is the so-called legitimate interest assessment, a kind of a special record of data processing activity that is much less complex than DPIA. Otherwise, we will see a kind of a trivialization of DPIAs, and this is already happening in Brazil. The another point when LGPD draws lines about risk regulation is when LGPD regulates the automate decision. LGPD considers clearly that an automate decision is by default a risky activity. Why? Because the law dedicates a specific provision to govern it, which grants a specific right to the data subject, the right of a review, and reinforce the right of information and transparency. So again, the riskier an activity is, legal obligations are calibrated heavier. And in this sense, the Brazilian DPA will play, again, a very, very important role in order to precise how those specifics, or at least tougher legal obligations, should take place. And another point is about the exemption from appointing data protection officers, the DPOs. And LGPD says that national DPA will precise in which circumstance data controllers are not obliged to appoint a DPO. What will be the probability criteria? I think, again, data processing activity that is risky or not will trigger differently this legal obligation to appoint data protection officers. So, in my view, just to conclude, LGPD has definitely adopted a risk-based regulatory rationality, which theoretically makes a lot of sense, but in practice, mainly taking into account the context of the Brazilian scenario, it is doubtful if it will succeed. Why? Because the risks of the risk regulation are higher when there is no well-designed institutional arrangement to better calibrate compliance obligations according to the risk level of the activity that should be regulated. In Brazil, we will face first a scenario that there is no culture on data protection. Second, a scenario in which our national DPA is not yet established, so we are losing time to calibrate better those legal obligations. Third, even when the DPA will be established, it will not be an autarky, which would be the best model in terms of administration law in Brazil. So all these elements may jeopardize such regulatory rationality. So what should we do, and specifically the private sector, in this complicated scenario? Private sector should anticipate this possible regulatory friction. How? By using codes of conduct to sectorally define what should be a risky data processing activity, and therefore what should trigger heavier, tougher obligations. The LGPD leaves room for that, and I think we should take advantage of it. So those are my considerations.
Excellent, Bruno. This is really very clear, and I like your examination of challenges as well, that this sort of very sophisticated risk-based approach in the law poses for everybody, and the perils if we don't get this right. So that's why it's so important to get the IMPD in place, right? But also for companies to be able to do these risk assessments.